Hello, good afternoon. How's everyone doing today? Hello, hello. Hi. Happy Thursday, everyone. How are you? Thank you so much for joining. How's everyone doing today? I wanted to hop on really quickly to talk about the public charge rule. I'm streaming both on Instagram and Facebook right now, so definitely tag your friends, family, anyone that you think would benefit from this information on the public charge rule. And for those of you who are joining me for the first time, oh, hi. Hello from Dubai. How are you? What time is it in Dubai right now? Thank you so much for joining all the way from Dubai. Awesome. So, for those of you who are joining me for the first time, I am Bianca Jordan. I'm an immigration lawyer. I help immigrants all over the world get legal status in the US. So, regardless of where you're living, as long as you're trying to live in the US, as long as you have an American immigration case, I'm able to help you. And if you're interested in working with me on your immigration case, you can give my office a call at 508 942 7497, or you can go to my website at brazenlegal.com/contact to book a consultation directly with me. Oh wow, it's 9:30 in Dubai. Dubai is on my list of countries to visit. So hopefully once the world reopens, I can go. All right. So, as I mentioned, I want to talk about the public charge rule. A couple days ago, I shared with you all that the Biden administration pretty much got rid of the public charge rule, or that it was on its way out. And I wanted to wait until I had the official guidance on what was going to happen with the public charge rule and how to move forward in your cases. So, the public charge rule officially gone. And now I have the guidance. So here I am to talk about it. So if you have any questions while I'm talking about this, please feel free to drop them in the comments and I will answer them either as I go or towards the end. If you want to wait and ask your questions then, feel free to do that. I'm pretty flexible as far as how I do my lives. All right. So great news. Public charge is gone. Public charge rule is no more. So, what does that mean? So, first, just to kind of give a recap for people that maybe don't know what the public charge rule is, and just a little bit of a history. We've had the public charge rule for quite some time. This isn't something that Trump created, it's just something that he made worse. So, the original version of the public charge rule was pretty nice to immigrants. It didn't require as much stuff as the Trump public charge rule required. It was pretty much immigration officers could deny your visa or your green card if they thought that you would become a public charge in the next 5 years. And what that means really is, did they think that you would be someone who would end up on public benefits such as like food stamps or public housing, something like that? And if they thought so, then they could deny you as a public charge. And back in the day, it wasn't really that cumbersome because even if the immigrant didn't have a lot of resources, finances, things like that, it really mostly depended on the petitioner's affidavit of support. So with the Trump administration, what they did was they put more of the onus on the immigrant to show that they qualified for the benefit and that they would not become a public charge at any time in the future. So even if, in the past, let's say an immigrant was trying to get a green card and they didn't really have a lot of money or anything like that. As long as the petitioner made enough money, as long as they could show that they had enough finances and assets and resources to take care of the immigrant that needed the green card or the visa or what have you, that was enough. But under the Trump public charge rule, they changed that. So less emphasis was going to be placed on the affidavit of support. So from day one, once the Trump administration announced that this was going to go through, it's been back and forth in court. I'm going to spare you all those boring court details. But the long and short of it is the public charge rule is gone. We don't have to deal with it anymore. Awesome news. So what does that mean for your cases? First and foremost, it means that you do not need to file Form I-944. That form has been the bane of our existence, both immigration attorneys and our clients as well, over the past couple of years, because it was asking for so much information. It was asking for credit reports, credit scores, proof you speak English, how much money do you have in the bank. Like, it was asking for so much information that was very cumbersome and difficult for people to really get. So I'm glad that this form is gone. It's not even on the website anymore. So you no longer need this application if you're filing your green card as of today, pretty much. If you filed your green card application already and you filed it with Form 944, that's fine. They're just not going to really do anything with it. They're not going to ask you any questions about it at your interview, which that's not really changing. They weren't really asking a lot of questions at interviews anyway. So it's not something that, they weren't really asking about it anyway, which is the other thing. Like, this was such a waste of time because they were asking for so much information from our clients, and then they weren't even asking about it during the interview. So you don't need to worry about this form anymore. If you filed your application with it, they're just not going to ask you any questions about it. If you filed your application without it during a time when the public charge form was not required, because again, it's gone back and forth through court. 1 minute it's on, the next minute it's off. So there are certain people that were able to file their green card applications without the public charge form, and now they're starting to send out requests for evidence asking for this form. You do not need to file this application form with your request for evidence. That doesn't mean that you can go ahead and throw out the request for evidence, because they are asking for other things sometimes. So when you get a request for evidence, their USCIS is just asking you for more documentation for your case. Sometimes it's as simple as they need a new copy of your birth certificate, or they need a copy of your I-94 or some type of proof that you came here legally. Other times they're asking you for information about your affidavit of support. Maybe they think that you don't make enough income to support or sponsor that immigrant. So they're asking you for more information. So that could be something that they're asking you for as well. So make sure that you're looking at the request for evidence to see exactly what they're asking you for. If all they're asking you for is the 944, you don't need to send in the 944. They say that you don't need to respond with that information. I am a little not so trusting, so I would still respond to that request for evidence with the USCIS guidance about the 944, and you can find that on their website. And then obviously if they're asking you for more information, submit that information as well, but just remind them that they don't need to, that you don't need to submit the 944 with that request for evidence. So again, to recap, public charge is dead and gone. The government is not even going to try to bring it back. At least the Biden administration is not. They've already expressed that they don't want to do this. They don't even have the resources to keep pursuing this because, again, it's been going back and forth in court. Some amazing attorneys have been fighting for our clients so that we don't have to do this super stupid, intrusive form. So the Biden administration is not even going to try to bring it back. You don't need it for your applications, for your green cards. That includes if you're overseas and you're going through consular processing. The public charge form has been on pause for a while anyway, so you officially do not need that form anymore. If you're filing for a green card application now, you don't need to file Form 944 with it. It's not even on the website, so unless you already had a copy saved, wouldn't be able to get it anyway. And if you got a request for evidence for the 944, you don't need to send them in the 944, but just keep an eye out for anything else that they might be asking for in your RFE. So we'll see if I have any questions. Clay F. Oliver, I have so many questions. Go ahead. You can ask all the questions you want. Just drop them in the comments. Let's see if I have any. I don't have any on Facebook yet. Let's see. See if I have any on Instagram. yeah, if you have questions, definitely feel free to drop them. I'll definitely stay on for maybe 5 or so minutes, depending on how many questions I get. But this is some really, really great news. I'm glad the 944 is gone. It was really just a wealth test to try to get people, to make it harder for people to come to the US legally. What about K1 visas? So, do you mean K1 visas as it relates to the 944 or in general? Assuming you mean for the 944 is gone. Like, so it doesn't, you don't need the public charge forms for anything. Not K1 visas, not green cards, for nothing. It's gone. Probably DM when I'm ready. Okay, that's fine. That's totally fine. Um, let's see, what other questions do you guys have? Let's see, none on Facebook. None on Instagram yet. Okay. All right, so it doesn't look like I have any questions. So I hope that means that I was super clear in explaining everything. So again, for the benefit of people that maybe are joining in late as well, public charge is gone. Don't need to file the 944 with your green card applications. If you already filed it with your green card application because you applied for a green card at a time when it was required, then they're just not going to ask you any questions about it. If you filed it at a time when it wasn't required and then became required, they're going to send you a request for evidence if they haven't already, and they may be asking you for the 944. You don't have to submit the 944, but just don't ignore the request for evidence, because sometimes they're asking you for other things as well, such as tax returns for your 2020 taxes. Maybe they say that the petitioner doesn't meet the income requirement, so they're going to need a joint sponsor. So don't just throw out the request for evidence. Make sure that you're addressing everything in that letter. I applied for a green card last year. The results, I don't know. So everything is taking a really long time right now for green card applications. And the reason for that is obviously because of COVID. We're still dealing with this pandemic, and USCIS is bound by the CDC guidelines as far as how many people they can have working at their facilities, and how many people they can have coming in for their interviews and their biometrics. Biometrics, which is a fancy word for fingerprinting and pictures, they're really backed up. They're still rescheduling some people from like March of last year. So almost a year, they're still rescheduling people that couldn't go to biometrics last year when USCIS was closed due to COVID. So they're really behind. I'm still waiting for biometrics on cases that I filed in September. So it's going to take a really long time for your cases to be processed. So definitely like try to be patient with USCIS. They're doing the best they can. They just can't have too many people in at a time. So that's part of why there are delays in cases. Not related, but any updates on the immigration bill going to the House on the 15th? Great question. So next week, so beginning Monday, is Immigration Week. And Congress is going to be considering a couple of immigration bills. One of those bills is going to be helping farm workers. So people that are working in agriculture will be able to have expanded options and opportunities to get visas as well as pathways to citizenship. And another bill that is going to be considered is the Dream and Promise Act of 2021. And this would provide green cards for people that have TPS, DED, and DACA. So if this goes through, then those categories of people I just mentioned would be able to have a green card, and then after 5 years, it could apply for US citizenship. So don't really have much on that right now. The US Citizenship Act, which is Biden's original immigration bill, it's still alive, but I don't know. I'm cautiously optimistic. I don't know if it will pass as is, because there's just so many awesome things in there, giving over 11 million people legal status. I don't think that it's going to pass just like that, unfortunately. But it's promising that Congress is still willing to consider immigration benefits for other immigrants as well, even if it's not like really considering the whole immigration, the whole Biden immigration bill. But as soon as I know more, I'll definitely keep you guys posted. We decide to do the K1 visa. Okay. So one thing to know about the K1 visa right now is that it's probably going to take a really long time for you to get that visa. And the reason for that is because there are currently like over 473,000 immigrant visa petitions pending at the consulate. Immigrant visas, you can also just think of them as green cards. So people are applying for green cards at the embassy, and the backlog is due to both COVID and Trump's April 2020 executive order that limited how many people or what categories of people could get green cards. So back in April 2020, he issued this executive order to kind of stop certain groups of people from coming here. Those groups included parents of US citizens, siblings of US citizens, married children of US citizens, spouses and children of green card holders, as well as other visa categories for employment opportunities as well. And because of that, that and COVID combined created such a backlog in the system that they have so many cases that they need to process. So again, as of February 2021, we've got 473,000 immigrant visa petitions pending. And so the focus is to get through those, which means that other visas, non-immigrant visas, such as fiancé visas, are going to be put on the back burner because the focus is getting this 473,000 caseload down. So even if USCIS processes the fiancé visa application fairly quickly, it's going to get held up at the embassy because they're of the embassies open and willing and able and ready to process K1 visas, I think it's only like 40 or so that are processing K1 visas right now. So it's going to take a really long time to get through the green card applications, but it's going to take even longer to get through the K1 visas because we don't really know when they're going to start picking back up again because the focus is green cards. So just expect that if you're applying for a K1 visa or aka a fiancé visa, it's going to take some time. And if you're applying for a green card as well, it's going to take some time too because right now they're starting to schedule interviews beginning in April of 2021. So what's going to happen is the National Visa Center is going to send you an email and let you know, hey, your case is ready for interview. It has been ready for over 60 days. When it's ready for interview, we'll let you know. And they're starting to send those emails out already. So if you haven't gotten that, I'd say by the end of this month, contact the National Visa Center to make sure that they have your most current contact information, that they have your most common or your most current email address. Because something that I see happen all the time is people, first of all, don't communicate with the National Visa Center and they close their cases. If you have a case at the National Visa Center, especially if it's a case where your wait time is going to be a long time, such as like 7 years if you're getting a green card through a green card holder, or if you're over the age of 21 and a US citizen is petitioning for you, you have to keep in touch with the National Visa Center at least once a year or they could close your case. I've seen that happen many, many times. Another thing I've seen happen a lot is people don't get notification about their case and that it's ready to move forward because they don't have a contact information. The NVC doesn't have contact information for that person. I've seen this happen a lot where people hire non-lawyers to file the I-130 for them, and that's all they file, and they don't really let the client know that they need to still keep in touch with the National Visa Center, and then the case closes. And if you're not able to reopen it, then you have to start all over again and wait out however many years all over again. So first thing I would do is contact the National Visa Center, make sure they have your most up-to-date contact information, and wait for that email to come, and they'll let you know when your case is ready for interview. Again, they're going to start scheduling things April 2021. They're scheduling interviews 60 days out. And again, we have 473,000 cases to get through. It's going to take some time. I would say at least a year and a half, unfortunately, and that's just for the green cards. TBD on how long it takes for the fiancé visas and other non-immigrant visas, but just expect that everything is going to take some time. Instead of waiting green card, we want to apply for K1. Is it possible? So as I mentioned, the K1 is going to take longer than the green card right now because of the green card. Hey, Katsi, because of the green card backlog. Are marriage visas considered non-immigrant visas as well? No. So marriage visas, if you're married to someone and you're trying to get a green card, that's considered an immigrant visa. If you're getting a fiance visa or a visitor's visa or a student visa, those are non-immigrant visas. So those are two different categories. And right now the focus is on immigrant visas. Carmel says, TPS holder, my daughter's a US citizen, will turn 21 in October. When can I send my application? So if your daughter's a US citizen and she turns 21 in October, then she can't file for you until she turns 21 in October. Just make sure that you don't have any issues like unlawful presence or anything like that, or not unlawful presence. As long as you came to the US legally, then your daughter can petition for you to adjust your status so you can get your green card here. Alrighty. Let's see if I have any questions on Facebook, which I do not. Okay. So I hope this was helpful. Like I said, I just wanted to hop on and talk about public charge and answer whatever questions you guys have, immigration related. You're welcome. Lots going on in immigration, and it's a lot of great news that's happening with immigration. So I'm happy to hop on and talk about all the awesomeness. I feel like over the past couple of years when I hop on or do a video, it's about bad news, but this week has been all great news. We've got TPS for Venezuela. We've got the Dream and Promise Act that's going to be considered next week, which fingers crossed it passes because people with TPS, DACA, or DED would be able to get green cards, and then public charge is gone. So I look forward to just sharing more and more positive news with you guys. Nini says, do you know how long is a wait for an IR visa for Port-au-Prince? I don't know how long the wait is going to be, but it's going to be a while. Not sure if you just heard, but I just said that there's 473,000 immigrant visa petitions pending, so consulates are prioritizing those over others. I know that Port-au-Prince is prioritizing those as well, and they are doing a few non-immigrant visas, such as student visas, but nothing else. So they're not really working on visitors visas unless it's an emergency situation. Most consulates still aren't really doing visitors visas unless it's an emergency situation. Emergency counts as a humanitarian issue, or you need to come to the US for medical treatment, something like that. That's what counts as an emergency situation. Port-au-Prince is not doing fiance visas anytime soon. They're really just focusing on the immigrant visa applications, especially those cases that have already been ready, but they couldn't move forward because of Trump's executive order. Scar, can I file for myself if I overstay my visitor in the US? I wouldn't recommend that you file for yourself. Well, first of all, when you say file for yourself, do you mean not using a lawyer? If so, I don't recommend that you work on your immigration case without an attorney. Not these days anyway. Immigration is complicated. You really do need to be working with a lawyer when you have an immigration case. But I don't really know what you mean by file for yourself. But if you overstayed your visa, if you had any fraud issues, if you've ever been in immigration court, you definitely should not be working on your case by yourself. I've been waiting over a year for IR1 interview in Haiti. That's normal, unfortunately. It's going to take some time. And it might take even longer because, again, the backlog. Yes, the backlog is very crazy. And between COVID and Trump's executive order, it's just been really out of hand. And Port-au-Prince isn't the easiest consulate to deal with, unfortunately. So just assume that everything's going to take some time. For most cases these days, assume it's going to take a year and a half. Unless you're petitioning for like a family member or something, or like a brother or sister, those cases are going to take a really long time. But um, like if you're getting a green card through a spouse, just assume at least a year and a half because of this backlog. But that doesn't mean that you shouldn't start your case. I always tell people it's gonna take a while, regardless of if you start now or if you start later, it's gonna take a while to get your case going. So the sooner you start, the sooner you'll get your benefit. The longer you wait, the longer it's gonna take to get your green card or whatnot. And I always encourage people at least do the I-130 for your family member, especially if you are applying for like a brother or a sister. Those cases right now are taking at least 15 years, and it's longer depending on what country you're from. So if you're from China, Philippines, India, or Mexico, those wait times are even longer. Like Mexico, I think right now for that category it's still around 27 years. So it really just depends on the country. But don't wait. Like start the process now. Get that I-130 going for a variety of reasons. Number one, it acts as an insurance policy in the event that, God forbid, you pass away and you're petitioning for someone to get a green card to come here and now you pass away. They can still possibly be able to come here even though you passed away, but you have to have that I-130 filed. And then also, eventually, things will get better. Right now, we're dealing with a shortage of staff as well as COVID-19 delays and backlogs due to the executive order. But over time, these wait times will get better. So the sooner you start the process, the sooner your loved ones can come here and join you in the US. So definitely get that going. Okay, so I don't have any other questions. It's almost 1. This is the last call for questions. So if you have any questions, definitely ask them now. Speak now or forever hold your peace, as they say. Let's see. I hope this video was helpful for you. I'll try to come on live more often as my schedule allows. Okay, so I don't see any more questions, so I'm gonna end the live soon. Thank you so much for joining me. If you have any questions, if you are interested in working with me on your immigration case, definitely call my office for a consultation so that I can sit down with you, look at your immigration file so we can get started. My phone number is 508-942-7497. If you're not in the United States, you can send us a message on WhatsApp, same phone number, 508-942-7497. You can also go directly to my website at brazenlegal.com/contact to book a consultation with me. Okay, last question. Can my husband petition for a visitor's visa while waiting for an interview? If you mean consular processing, maybe, but the issue that sometimes happens is if you already petitioned for someone to get a green card and then that person tries to apply for a visitor's visa, they might be denied because the immigration officer can look and see that someone's petitioning for them to get a green card. And they could say, well, are you really only going to the US to visit? Or are you really just trying to like skip ahead in line and get a visitor's visa and just wait for your green card in the US and try to adjust? So it is possible to get a visa even though you have a petition pending, but you really have to show the immigration officer that you're going to go back to your home country, that you really are just trying to visit, that you're not trying to just get a visitor's visa to wait for the green card in the US. All right. Well, thank you so much for joining. I hope you guys have an amazing afternoon, and I will talk to you guys later. Bye.